Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers obscene gestures, the collective knowledge doctrine, and resisting, and is brought to us by Flex Your Rights and Lackluster's channels. Be sure to check out the description below and give them the credit that they deserve. On March 10th, 2022, Hubert Josh Hall was leaving his residence in Wright City, Missouri, when Officer Jose Malta Gonzalez of the Wright City Police Department noticed that several of the vehicles parked in Mr. Hall's driveway did not have license plates. Officer Malta parked his vehicle and began an investigation into the unregistered vehicles.
Not too bad. Are these your vehicles?
Yeah, well, this one isn't. Those two are.
Okay, so what's going on with them? They don't have any registration on them.
I just bought that one and that one. I took the head off of. I'll get a cover for them, man, but you get off my property now.
No.
I'll get a cover for them.
I'm placing ordinance stickers on all of them.
I'll get a cover for them.
You can't do that. That's not how it works.
Okay, you put your stickers on. Fine.
Okay, then you're going to be cited for it.
Hey, put your stickers on. I'll take care of it.
I'll just issue citations.
Officer Malta informs Mr. Hall that he will be issuing him citations for the unlicensed vehicles. Under Section 217.010 of the Wright City Code of Ordinances, a so-called derelict vehicle is defined as, quote, any inoperative, unlicensed, partially or fully dismantled, wrecked, or junked motor vehicle, trailer, all-terrain vehicle, or vessel situated, parked, kept, or stored upon any private property, with or without the consent of the property owner. Section 217.015 of the Code of Ordinances states that, quote, the City of Wright City does hereby determine and deem derelict vehicles to constitute a public safety hazard, and, as such, prohibits the storage of derelict vehicles within the City of Wright City. Although the ordinance does not apply to motor vehicles that are completely enclosed within a locked building or locked fenced area and not visible from adjacent public or private property, the ordinance would prohibit Mr. Hall from keeping the unlicensed vehicles in his driveway. However, the Wright City Police Department's standard practice is to place a warning sticker on derelict vehicles, with a 7-day grace period to remedy the violation. If the officer returns after 7 days and the derelict vehicle is still an issue, the officer will then issue a citation. Therefore, while likely not illegal, Officer Malta's decision to forego the 7-day grace period and immediately cite Mr. Hall was a deviation from the department's standard practice.
48, can you copy a VIN? Okay. I'll take my time.
Pulling up here shortly.
10-4. Try and get a stop on that GMC Suburban. It just left.
That's clear.
He wasn't a fan of me being here.
Is it his residence?
I believe so. He wanted to flip me off and threaten me to get off the property.
Officer Malta claims over the radio that Mr. Hall flipped him off and threatened him, when, in fact, Mr. Hall only gave him the middle finger. While it is firmly established that so-called true threats of physical harm are not protected by the First Amendment, it is clear from the body camera footage that Mr. Hall made no such threats. However, the First Amendment does protect communicative gestures such as giving the middle finger, which means that Mr. Hall could not be criminally prosecuted or even legally detained based solely on the fact that he quote-unquote flipped off Officer Malta. Although raising a middle finger is clearly not so-called speech in the ordinary sense of the word, as the Supreme Court noted in the 1989 case of Texas versus Johnson, the protections of the First Amendment are not limited to spoken or written language, and, now quoting, conduct may be sufficiently imbued with elements of communication to fall within the scope of the First and 14th Amendments. Now, although the Supreme Court has not decided a case regarding First Amendment protections for raising a middle finger, it did determine in the landmark 1971 case of Cohen versus California that profanity was protected by the First Amendment, holding that a state may not, now quoting, make the simple public display of this single four-letter expletive a criminal offense. Likewise, in the 2021 case of Garcia versus City of New Hope, the 8th Circuit Court of Appeals, which has jurisdiction over Missouri, held that although raising a middle finger at an officer was a, quote, rude and offensive gesture, it was nonetheless, now quoting again, a constitutionally protected speech activity. Accordingly, it is almost certain that a court would conclude that Mr. Hall's use of the middle finger was protected by the First Amendment, and therefore could not justify an arrest or detention.
Good, can I help you?
Got your driver's license?
What do you need my driver's license for? What'd you pull me over for?
What's that?
What'd you pull me over for?
For your threats that you made to one of our officers.
That's not a threat. What threat? What threat did I make to an officer?
I need your driver's license proof of insurance.
You need a reason to pull me over.
I just gave you that.
For what threat? I didn't make any threat to any officer. I haven't. No, I am not, because I did not break the law.
So you're not going to give me your driver's license and proof of insurance. Is that correct?
For what?
I just told you.
For what threat?
Okay, I'm not going to keep going through.
Threatening an officer is not a crime. I didn't threaten to do anything to
It is
him.
a crime, yes.
Flipping an officer off is not a crime.
A threat to an officer is. I'm not going to
Flipping an officer off is not a crime. It's a constitutionally protected activity, right?
Hop out or I'm going to break your window.
It's a constitutionally protected activity to flip an officer off.
That's fine. You can flip him off. You can't make threats to him.
I didn't make what threat?
This is
What
your last
threat?
chance or I'm gonna break your
What
window
threat?
and I'm gonna
Okay,
arrest you.
first tell me what
No,
threat I made to
sir.
him. What
Now
threat?
you are
What
under arrest.
threat?
I'm gonna break your window.
What threat did I make to him? What threat did I make to him?
Driver's license. Get out.
I
of the
will.
car,
Here's
you're
my
under
here's my
arrest.
thing.
Out of the car.
Detective Christopher Beard initiates a traffic stop on Mr. Hall, and when Mr. Hall asks why he has been stopped, Detective Beard states that he is being detained for making threats against Officer Malta. In his coverage of this incident, Lackluster indicated that Officer Malta claimed in his report that Detective Beard radioed him to ask about the type of threats Mr. Hall made, and that Officer Malta informed him that Mr. Hall had only displayed his middle finger. If this conversation even occurred, it is unclear whether it happened before or after Detective Beard pulled Mr. Hall over. But if Detective Beard initiated a traffic stop on Mr. Hall knowing that he had done nothing but flip off Officer Malta, it is highly probable that a court would find the traffic stop to be unlawful. And assuming for the sake of argument that Detective Beard was not aware that Mr. Hall did not actually make any threats, it is still unlikely that a court would conclude the traffic stop was constitutional. In some situations, courts have held traffic stops to be constitutional, despite the fact that the officer initiating the stop did not have sufficient information to form reasonable suspicion on their own, based on the so-called collective knowledge doctrine. As the Eighth Circuit Court of Appeals explained in the 2008 case of U.S. v. Thompson, quote, "The collective knowledge of law enforcement officers conducting an investigation is sufficient to provide reasonable suspicion, and the collective knowledge can be imputed to the individual officer who initiated the traffic stop when there is some communication between the officers." For instance, in the 2005 case of U.S. v. Williams, the Eighth Circuit determined that the collective knowledge doctrine was sufficient to attribute the knowledge of other officers on a team to an officer who received a radio request from the team to stop the vehicle without underlying details regarding the reason for suspicion. As such, if Mr. Hall actually had threatened Officer Malta, a court would likely find that the traffic stop was supported by reasonable suspicion, even if Detective Beard had no personal knowledge regarding the nature of the threat. However, because Officer Malta did not himself have the reasonable suspicion necessary to detain Mr. Hall, the collective knowledge doctrine would not transform the traffic stop into a lawful one simply because Detective Beard may have believed the stop was supported by reasonable suspicion based on Officer Malta's misrepresentations. As the Eighth Circuit noted in the 2004 case of U.S. v. Jacobson, although the officer stopping the vehicle is not required to know the specific facts that caused the stop, they must, quote, "rely upon an order that is founded on reasonable suspicion." Therefore, it is probable that a court would conclude the traffic stop violated the Fourth Amendment, even if Detective Beard was acting on good faith belief that Mr. Hall had threatened Officer Malta. After he stepped out of the vehicle, Mr. Hall was arrested and taken to the Warren County Jail, where he was held in custody for 5 hours before being released. The Wright City officers towed Mr. Hall's vehicle, and he was issued municipal ordinance violation citations for disorderly conduct, failure to comply, and resisting. They also issued him 3 citations for the derelict vehicles in his driveway. Mr. Hall filed a complaint, and 1 week later he met with the Chief of Police and Lieutenant Tim Matthews.
I had an opportunity to review your case.
Okay.
One thing I'll say is that to begin, I am going to be voiding all the charges, all the summonses that were issued to you.
Awesome.
I've also spoke with the tow company, and they have agreed to refund the expense you had.
$400. They charged me $400.
And you will be refunded every penny of that. So let me explain to you why. What we have here is a Sydney ordinance that has been on the books for some time that shows that the officers were acting in good faith in accordance with the city ordinance at the time.
Yeah, I know the city ordinance. I'm aware of it.
Sure.
I knew he had a right to be on my property.
Well, this is specifically the manner in which why they placed you under arrest, not specifically the derelict vehicle ordinance. So this is the ordinance labeled disorderly conduct, if you recall getting that ticket from the arresting officers. And the subsection of the ordinance that they used to place you under arrest was this language here. Whenever I reviewed this case, I believe
Obscene
that
gestures are constitutionally protected.
you're-
You can't
if-
make laws that go above and beyond the
Well, just-
Constitution.
if you give me an opportunity to
Okay,
finish.
okay, go ahead.
Josh.
I'm sorry.
Okay.
I'm sorry, go ahead.
This was on the books. This was the ordinance that they enforced, that they used to place you under arrest.
Okay.
When I had the opportunity to review the case, I agree with you that I believe this is in conflict with the First Amendment.
Okay.
Okay, that is protected speech. Because of that, all subsequent actions following the traffic stop, regardless if you were guilty of them or not,
Yeah.
are not going to be enforced. Because I do not believe that they had a constitutional right to
To
stop
pull me
you
over,
in the
yeah.
first place.
I've seen people get pounds of
So-
marijuana thrown out of court for
So-
unconstitutional stops.
Lieutenant Matthews informs Mr. Hall that he is voiding all of the citations against him because he believes the traffic stop was conducted in violation of the First Amendment. As Lieutenant Matthews discussed, at the time of Mr. Hall's arrest, the city's disorderly conduct ordinance prohibited so-called obscene gestures, which generally will fall under the protections of the First Amendment. As to the other two charges, failure to comply and resisting, Section 310.020 of the Wright City Code of Ordinances, which uses the same language as Section 300.080 of the Missouri Revised Statutes, states that, quote, "No person shall knowingly fail or refuse to comply with any lawful order or direction of a police officer." Accordingly, Mr. Hall could not be convicted of failure to comply unless he disobeyed a lawful police order. And as the traffic stop was almost certainly conducted without reasonable suspicion, it is likely that a court would conclude that none of Detective Beard's orders were lawful. Likewise, under Section 210.390 of the Code of Ordinances, which mirrors Section 575.150 of the Revised Statutes, quote, "A person commits the offense of resisting or interfering with arrest, detention, or stop if he or she knows or reasonably should know that a law enforcement officer is making an arrest or attempting to lawfully detain or stop an individual or vehicle, and for the purpose of preventing the officer from effecting the arrest, stop, or detention, he or she resists the arrest, stop, or detention of such person by using or threatening the use of violence or physical force, or by fleeing from such officer, or interferes with the arrest, stop, or detention of another person by using or threatening the use of violence, physical force, or physical interference." Although the ordinance and statute also state that, quote, "It is no defense to a prosecution that the law enforcement officer was acting unlawfully in making the arrest," as the Eastern District of the Missouri Court of Appeals explained in the 2020 case of State versus Stewart, which applied Section 575.150 of the Revised Statutes, quote, "By statute, the stop or detention must be a lawful stop or detention for a felony, misdemeanor, infraction, or ordinance violation. Therefore, it is probable that a court would determine that Mr. Hall could not be convicted of resisting or interfering with the traffic stop because it was unlawful."
So again, I understand that you're an argumentative individual. I am not.
I'm
interested
not
in
an
hearing you
argumentative
argue-
individual. I'm a very polite
Sure.
person. I have 7 kids.
So
I have been violating my rights before I knew what my rights were.
the whole point here, and the reason why I've called you, the reason why I wanted to reach out to you, is that your point here of your ability to make obscene gestures toward police or protect under the First Amendment, as the police department, we agree with you. This subsection of the ordinance, we've already addressed this with our legal counsel that represents the city, and this ordinance will be amended to remove anything that's in conflict with the First Amendment.
Okay.
As such, you will be the standing case law that amends this for all future contact, and this ordinance will be amended to where this will never happen again.
Okay.
Hopefully now we can put this whole issue behind us. Again, I have no reason to suggest the officers didn't act in good faith because that ordinance was on the books. That ordinance is going to be amended.
Okay.
Yeah, so prior to even calling you, the actual hard copies of the tickets were stamped red and void. Inside of the computer system, I voided all of those out. With respect to the derelict vehicles, I voided those too.
Lieutenant Matthews remained true to his word and voided all of the citations against Mr. Hall. He also followed through with his pledge to amend the disorderly conduct ordinance, as a news article from June of 2022 reported that the city alderman voted to replace the antiquated ordinance after Lieutenant Matthews initiated the change. The ordinance now prohibits so-called fighting words and abusive language uttered in a loud or threatening manner, but no longer bans so-called abusive or obscene language and obscene gestures. In October of 2022, Detective Beard was fired following an investigation into Mr. Hall's arrest, and Detective Beard subsequently filed a lawsuit alleging wrongful termination and other mistreatment. As of the date of writing this episode, the case is still pending. It is unclear whether Officer Malta faced any disciplinary action for his role in Mr. Hall's arrest. On December 12th of 2022, Mr. Hall filed a federal lawsuit alleging multiple constitutional violations and state law claims, and on November 15th, 2023, the case was dismissed after Mr. Hall agreed to settle for $100,000 in compensation, which Lackluster reported Mr. Hall plans to use to open a pet store. Overall, Officer Malta and Detective Beard get an F for maintaining hostile demeanors throughout their encounters with Mr. Hall, fabricating allegations against Mr. Hall, and arresting him for simply directing a First Amendment protected gesture at Officer Malta. Officer Malta appears to have blatantly lied about Mr. Hall threatening him, presumably in order to justify asking his fellow officers to detain him. And although it is possible that Detective Beard did not know that Mr. Hall did not threaten Officer Malta at the time he initiated the traffic stop, he gets an F regardless based on his aggressive conduct and repeated threats to break Mr. Hall's window. This encounter demonstrates how an untruthful statement from a single officer can snowball and cause other officers to also violate a citizen's rights. Lieutenant Matthews gets a C+, because although he admitted the unconstitutionality of Mr. Hall's detention and voided the citations issued to him, he also claimed to believe that the officers were acting in good faith when the footage of the encounter clearly shows otherwise. Despite Lieutenant Matthews' contention that the officers were relying on the disorderly conduct city ordinance when detaining Mr. Hall, Detective Beard repeatedly stated that Mr. Hall was being stopped based on Officer Malta's fabrication that he had threatened him, with no mention of him making an obscene gesture or committing disorderly conduct. Now, this grade was challenging to assign, as I believe Lieutenant Matthews deserves recognition for dropping the charges against Mr. Hall and taking the steps to initiate the amendment of the outdated disorderly conduct ordinance. However, I cannot accept his justification of the officer's actions as good faith reliance on the disorderly conduct ordinance when Officer Malta unquestionably made an unfounded accusation against Mr. Hall. And to me, Lieutenant Matthews' explanation seems more like a poorly reasoned excuse for the misconduct of his fellow officers. Mr. Hall gets an A for strongly advocating for his First Amendment rights, challenging the illegal traffic stop conducted on him, and taking appropriate legal action after his arrest by fighting the citations against him, filing a complaint, and pursuing a lawsuit against the officers involved and the city. Although he did, quote-unquote, flip off Officer Malta, as we discussed in this episode, such conduct is entirely protected by the First Amendment. And although I would not necessarily recommend that individuals direct this gesture at law enforcement officers during police-citizen encounters, Mr. Hall was well within his First Amendment rights to express himself this way. I applaud Mr. Hall for his commitment to pursuing justice after this encounter, and wish him the best as he embarks on a new adventure with his pet store. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.